they hardly ever do on true police victim crimes. They just don't do it, and they're told not to. Not only did it drop down from the charge to a misdemeanor, but then also opposed to the normal procedure of a case like this, it went into pretrial diversion. Having gone into pretrial diversion, he successfully completed that. They dropped the charges completely. So 8 years ago, he was in fact over-arrested for something. The initial prosecutor to review it identified it as being an overcharge, dropped it down to misdemeanor, pretrial diversion, and it was dismissed outright. It bears no significant probative value, both because it's ancient in time, it's ancient in act, and the way it was handled by the system suggests that it was a non-event even to begin with. I want to make sure that we're clear, however, that if in fact the state brings in this one prior bad act, suggesting that my client is now a fighter or something, that the very witnesses that the state attorney's office has relied on throughout this case, particularly those interviewed by the Florida Department of Law Enforcement, and most particularly the Federal Bureau of Investigation, when they did their "Are you a racist?" interview of everybody who my client talked to, including family members, a lot of people from retreat.
Okay, can you get to your point?
The point is that there are probably 30 witnesses to counter this one witness that my client is peaceful, nonviolent, friendly, mellow, and everything else. Information the state, and the reason why I present it now, information the state is well aware of.
I told you when we're at the bench, I really don't like these, you do this, I'm going to do this argument. Everybody, each side is available to present whatever case that they want to present within the bounds of the law and the rules of evidence, and they do so at their own peril for opening any doors that may be available. So I don't, you all are experienced lawyers and you know what you can and cannot do or should and should not do. So I don't want to hear, if you do this, I'm doing that. That will be based upon a ruling from the court as to whether or not any particular door has been opened from either side. Mr. Manti, you have indicated that you don't even know if this witness is available. We now know what information you seek to elicit from this witness, and we can have argument if he is in fact available and you're seeking to have him testify. We can have argument before he testifies. Are there any other rebuttal witnesses that the state would be seeking to call?
No, Your
Honor. Right. Based upon that, I don't know if you're going to have any rebuttal, so we'll wait to see whether or not.
There's been no rebuttal. I don't think it's appropriate.
Well, I don't know whether or not.
If you allow this, I'm sorry.
Right. So we'll take that issue up tomorrow. I would like to then inform the jury as to where we're going in this case. So there will either be some more testimony in the morning. We'll do our jury instructions tonight, finish them up in the morning, and I'd like to tell them that we're going to start closing arguments tomorrow. How long does each side anticipate that they will take in closing?
Since we have opening and closing in terms of, I would say 3 hours.
I presume that only one attorney will be handling closing for the state, correct, as per your normal course?
Well, I think in any other times that we allow another attorney to do the rebuttal. I've always done it that way, so if that's how they choose to do that.
I object.
Okay. Your objection's overruled.
I think 3 hours is certainly enough.
Are there going to be a lot of conversations or rulings having to be made by the court concerning the jury instructions, other than what we do with a self-defense instruction in light of the Supreme Court's review of that instruction?
There's that. There's an addition based upon a case that I've just mentioned to the state but can present to the court as well as Gibbs versus State, which is a slight modification to the self-defense instruction to identify a word that's not otherwise defined. I'll tell you now, I'll tell you when we get together. Then there is a circumstantial evidence one that I think that has certainly been presented to the jury as an existing element for them to consider. And
when do you anticipate having your proposed instructions to both the state and the court?
I told him I'd get it to him tonight, so I'll get him the case law and those are the two instructions. We have some argument on the applicability, inapplicability of manslaughter to the facts of this case. I'd like to argue that with you at some point. I think those are the three main, with consultation with Mr. West and my client. There may be a couple of other polishings, but I think that's the
How long do you
focus.
think that argument is going to take on the jury instructions? I'm just trying to get a
Sure.
feel for timing.
Oh, I think half an hour. I mean, I think it's pretty straightforward. Circumstantial evidence is what it is. I think it's discretionary with the court, but when the facts support it, it's allowable, so I'm not going to retrain anyone on that. The Gibbs case, it just defines provoked because it's not otherwise
At 10 in the morning, the state can start their 2 hours, if there's not going to be any further rebuttal, could start their 2 hours portion of their closing statement. They could go to lunch. The defense can do their 3 hours, and the state can do their hour rebuttal, and we can get it to the jury by tomorrow evening or have them recess for the evening and come back Friday morning. I'm going to leave it up to them as to how long they would like to do that for. So
Is now an opportunity, maybe after the jury's
we
released,
need to do the Donnelly hearing also.
to Donnelly, and also to address the issue of their rebuttal. And the reason why I suggest that now rather than tomorrow is if you allow that, we may well have, I don't want to use the quid pro quo argument to you, but that's going to take a lot of work to get rebuttal witnesses together, a great deal of work, including all the other witnesses to that event and the other
Well, none of
things.
this may even occur if that witness is not available. Is there any way that you can let this court know sometime soon whether that witness is available at all?
Yes, Your Honor, I'm trying to check now, actually.
It may be a non-issue.
Okay, then we'll wait and see if we need to have the argument, I guess. Okay.
Let's go ahead and bring the jury in, and I'll excuse them for the day, and then we'll begin on Donnelly. Go from there.
Before they come in, you are also then going to address the argument of whether or not that door has been opened before they begin their rebuttal and whether or not it's appropriate? I just want to make sure that's not waived. They sort of
Nothing has been waived. I just want to know the availability of that witness because none of it may be an issue.
Yes, Your Honor. You should record clear as to coming in. We did file the judicial notices on the
Jury present, Your Honor.
meetings and exhibits. They're in.
I think I need to make sure that you need
Please be seated.
please the two.
Ladies and gentlemen, again, we have some more work that we need to do outside your presence, and instead of keeping you back there in the jury room, I'm going to let you recess for the evening. I just wanted to tell you the state of where we are. I hate to ever tell anybody what I anticipate will happen, because as soon as I say it, something else occurs. But we do anticipate to go to closing statements tomorrow. And since there'll be some more work that we would have to do in the morning, I'm going to have you come back at 10 a.m. So it gives you a little bit more time in the morning. When I have you recess for the evening, I want to give you the instructions. During the overnight recess, you're not to read or listen to any radio, television, or newspaper reports about the case. You're not to discuss the case amongst yourselves nor with anybody else. You're not to use any type of an electronic device to get on the internet to do independent research about the case, people, places, things, or terminology. And you're not to read or create any emails, text messages, tweets, social networking pages, or blogs about the case. Do I have your assurances that you will abide by these instructions? With that, put your notepads down, follow Deputy Jarvis, and have a good evening. Please be seated. What's been handed to me is State's Exhibit 213. Is that the correct
That's the
exhibit?
replacement, Your Honor.
Okay,
to-
both sides agree? And then I've been handed Defendant's Exhibit 40, which is the weather report for February 27th. Both sides agree?
Yes, Your Honor.
Then you are going to look at Defense Exhibit 39. Is there any objections to that,
Judge,
Trish?
they emailed it to me a few minutes ago. We're verifying it, so there shouldn't be, but I just want to verify it, so it might take a little bit longer because they revised it and we just need to check.
All right. Are we ready to proceed about the state's motion for sanctions regarding Mr. Donnelly?
Yes, Your Honor. Your Honor, previously the state had filed a request to have Mr. Donnelly's testimony stricken, in part due to the discovery violation that was asserted based upon his radical change in his testimony. And while the court found that there had in fact been a discovery violation, you found that the state had failed to establish enough procedural prejudice under the Scipio, SCIPIO case, and as well as Evans and Cassica that we had discussed at that time. And so the request for any curative measure at that time was denied. However, I did indicate to the court that we believed that there was some indication that the witness, in addition to that discovery violation and change in his testimony, had apparently been present in court. I did not have the confirmation at that time. However, I have since obtained it. We did provide counsel, and I believe the court as well, copies of photographs, essentially clips from videos. The witness, Mr. Donnelly, was in fact present at least 2 days of the court proceedings, that being the 25th and 26th of January, seated with or immediately behind the defendant in the defendant's family section, and is captured on those screens and is present. I don't think there's even any real dispute that that is him. My understanding is that the concession is that it is in fact that witness. It is subsequent to his sitting through 2 days of testimony, which included a number of witnesses, including Diana Smith, the crime scene tech, and significantly Jane Serdyka, who identified the voice that she heard screaming as a younger man's voice, a boy's voice, I think was her word, something to that effect. Following his presence in court, the witness went home on the weekend, decided to listen to the tape, contact Mr. O'Mara, and we know the history from there. I will point out that even since that time, we have learned that similar things have happened with 2 additional witnesses. As we learned yesterday during the testimony of the defense witness, Mr. Shoemaker, witness John Good, who remained under subpoena and subject to recall, actually met with defense counsel as well as Mr. Shoemaker to discuss and address and adjust and therefore change the defense animation exhibit. Further, right here today, we heard from Ms., you'll have to forgive me, Bertalan, who also indicated that she was present and had watched, or maybe not present in court, but had watched and participated, had watched and observed at least a portion of the trial proceedings, including the testimony of, I believe she said, the defendant's uncle. And so we have, I think, established now, as far as procedural prejudice goes, that the witness in question, Mr. Donnelly, subsequent to sitting in court for 2 days, took it upon himself, I think is his representation, to go ahead and do something which turned him from a, as the case law indicated earlier, a non-witness into a witness. And Mr. Good certainly was in contact with and discussed potential testimony as well as actually a defense exhibit, again in violation of the rule of sequestration. As it relates to sequestration, I did, I think that the relevant case law as it relates to what to do about potential violations of that rule is set forth in the 4 cases I provided to Your Honor. Again, I think the Scipio and Evans and Cassica line of cases indicate that there does need to be some showing of procedural prejudice. I think the change in testimony as well as the discussions had with Mr. Good in particular, as well as to a lesser extent the third witness that we heard from today, Ms. Bertaland, certainly the cumulative effect of all of those are the ones we know about at this point in time, have sufficed from the state's perspective to establish that there has been some procedural prejudice now, sufficient for that. As far as the violation of the rule of sequestration, obviously the court has contempt powers over and above and independent of any of this. However, the cases that I've cited to the court are, first off is the McKinsey, M-C-K-I-N-Z-I-E, which is the first DCA case, 845 Southern 2nd 316. And the first issue, or the first order of business, is to determine whether or not violation was with knowledge or consent or connivance of the defendant or his counsel. I believe, as to Mr. Good, the representation I've heard is that certainly that was with the knowledge of counsel. I don't know, I think the representation as to witness Donnelly has been that that was without necessarily the knowledge of counsel, although whether defendant or any other member of his family knew, I think is certainly open to question given the location in the courtroom that the witness was observed. Second issue is if it is not with such knowledge, connivance, or consent, then the second way to determine this, and I'm reading from page 2 of the court's copy at the bottom of the left-hand column, second test to determine whether a sequestration violation should preclude the witness from testifying, and the state's position is, since they've already testified, the remedy is, at least as to Mr. Donnelly, the prior request to strike his testimony and give a curative instruction, was put forth in Steinhorst versus State, that's S-T-I-N-H-O-R-S-T. The Supreme Court restated an earlier holding from a case called Dumas, D-U-M-A-S, further explained that the test to determine whether to exclude a witness is whether the sequestration violation changed the witness's testimony from what it would have been had the rule not been violated. So again, before I get to the other cases, the change in the testimony, certainly there's been a change in the exhibit, the animation, as testified to by Mr. Shoemaker, and I think Mr. Donnelly's change in testimony is pretty radical and pretty evident. He went from testifying in his deposition that he hadn't heard anything and didn't recognize a voice to testifying at trial that he had heard something now and did recognize a voice. The next case is Scott versus State. That's 17 Southern 3rd, 766. It's a case from the 4th DCA. And I believe it's referenced as page 4 of the opinion in question, or the copy. I'm sorry, beginning on page 3 and continuing on to page 4. But beginning on page 3, in this scenario, there was a defense witness who was present in court and then opted to express her desire to testify. She was attempted to be called by the defense. The court ruled, much like this court has ruled, that there had been a discovery violation. I don't know that this court has yet determined whether that was willful or substantial, but the trial court in Scott did, and expressed concern about the violation of sequestration, and then said that the court believed and found that the defendant was not acting in good faith, but purposely trying to thwart the prosecution, including dropping the witness on the lap of the prosecution at 1:30 yesterday. I think the court's comments in that case are illustrative. The court said, I'm mindful of the law, but I think that Mr. Scott has been knowingly and intelligently making certain decisions in this case to his advantage and to the prejudice of the state, and to allow this witness to testify at this time would be, and the court finds, will be prejudicial to the state. The court found that a Richardson discovery violation, and there is prejudice to the state in this matter that cannot be reasonably overcome based on the totality of circumstances. The court goes on to say, at the bottom of that column, although the rules authorize a trial court to exclude a defense witness because of failure to disclose the witness, the law has well established the exclusion of a witness is a severe sanction, which should be resorted to only after the alternative available remedies have been fully considered and deemed insufficient. In this case, as to witness Donnelly, there is literally no way to unring that bell other than a curative instruction and instruction to disregard his testimony. So while we recognize that what we're asking for here is not quite the nuclear option, but a severe sanction, I believe the case law supports that it can be done. The Scott court approved that in that scenario. The next case in order is Steinhorst itself, which is the Florida Supreme Court case from 1982. It begins on, I believe, page 7 of the copy of this court's opinion. At the very bottom, headnotes 8 and 9, where they're again referencing the old Dumas case. And they indicate that Dumas does not outline the circumstances under which a court may properly exclude a witness for violating the rule. The test, however, is whether the testimony of the challenged witness was substantially affected by the testimony he heard to the extent that his testimony differed from what it would have been had he not heard the testimony in violation of the rule. Defense counsel in that case tried to show the testimony of the witness may have been affected by what he heard. The state attorney elicited testimony contradicting this. The court made a determination in ruling. Finally, the Dumas case sets forth the older test, still valid, but as I think Scott made clear, only one of a couple different possible ways. On page 2 of the opinion, in the right-hand column, if the witness disobeys the order of withdrawal while he may be proceeded with against for contempt and testimony open to comment to the jury by reason of the conduct, he is not thereby disqualified, and the weight of authority is that he cannot be excluded on that ground merely, although the right to exclude under particular circumstances may be supported within the sound discretion of the trial court. Your Honor, the state's position is that we believe, given both the nature of what went on, particularly as to witness Donnelly, to a little lesser degree witness Good, and to a significantly lesser degree Ms. Bertolin, as well as the cumulative nature of it and the radical change that occurred to both witness Donnelly's testimony as well as the exhibits and items discussed by Mr. Good in connection with Mr. Shoemaker's testimony. The state believes and would renew our request. Obviously, the court can proceed in any fashion it wishes via contempt proceedings against any of the 3 witnesses, but we would renew our request as to witness Donnelly that the court issue a curative instruction to the jury and order his testimony stricken or a combination thereof. Thank you.
If I may, Mr. Manti, if I might approach Your Honor with some case law supporting different conclusions. I don't know if we're now opening the door, so to speak, to all those potential violations. We want to talk about Mr. Good and I forget who, Ms. Bertolin, but maybe we can add to the list Shipping Bow, who seemed to have had a conversation with the state attorney's office where he materially changed 2 particular parts of his conversation.
I think that it's a violation of the rule of sequestration for the attorneys to have a conversation with the potential witnesses.
I didn't think so. It just seemed to be being argued by the state. So let me focus my concern with that argument.
Well, let me just, before you start your argument, as far as Bella Tran, who testified today, the state covered that in cross-examination. That's a non-issue at this point.
Okay.
The state hasn't asked for any sanctions regarding Mr. Good, so that's not an issue as to this point. So it's as to Mr. Donnelly.
My only concern is that if they're referencing these as though they want to sort of pile on and suggest that you should consider that we've ignored the rule all over the place, I have to respond to it.
The court is very concerned over the fact that there are 3 alleged instances of violation of the rule from defense witnesses, and that's something that should have been known by counsel to not have occurred. The court will tell you that I am investigating the possibility, I think the person may have been on both witness lists, of another person who may have violated the rule of sequestration, although they have not been called as a witness, but I am investigating that also, so I wanted to inform both sides. And
Great.
if you want me to tell you at a later time, I don't want to say the name
Sure.
until I conduct the investigation.
That's
But I
fine.
will tell you up at the bench if you
Sure.
want to know after you finish your argument, but please go ahead.
As to the court's
proceed.
concern regarding Mr. Good, let's clear the record on that. Mr. Good and Mr. Shoemaker never spoke. Mr. Good was shown by me the animation to confirm with his trial testimony that it was accurate. He told me it wasn't. I had him tell me, and I knew, of course, from his testimony, the areas of concern. I then went to my expert, an expert who, as this court knows full well, could have sat in the back of the courtroom throughout the entirety of the trial in order to get that information. I think it's absurd to suggest that an animation expert can't get information from trial testimony when it is that very trial testimony that he is supposed to do. So,
In all due fairness, it was my questions of Mr. Shoemaker yesterday or last night during his testimony when he said he got the information from a conference with counsel and another person. I asked, who was that other person? So that came from the
Okay.
court asking the question.
okay, just so
go
we're clear,
ahead.
they never spoke because I was the intermediary to get over. Since that was just directly to Mr. Delarionda.
No, yes, I think
Okay.
that the witnesses are allowed to talk to the attorneys.
And there's, I guess, the discovery violations for failure to notice us will be taken up at a later time if I
Right.
file a motion.
This is relating to Mr. Donnelly, that the evidence presented to the court by way of pictures is that
Okay.
he was sitting in this courtroom after the rule of sequestration had been invoked.
Okay, let's talk then about the substance of that, and I'll then get into the case law. Mr. Donnelly was here, it seems, from my review of the evidence given to the state on days 2 and day 3 until the first morning break. And we'll have some testimony as to why he was removed from the courtroom at that point. Here's the testimony that he was exposed to that may have affected his testimony. Because I think, as we get into it, obviously, the impact on a witness and the whole purpose for the rule of sequestration is to avoid infecting one witness with another witness's testimony. So he did hear from Wendy Dorival. And you know her testimony as, so he heard that. It seems, at least he was in the courtroom for that. He heard Ms. Dorival. He also then had an opportunity to hear Donald O'Brien, the Homeless Association. And then he had a chance, after that was done, to listen to Ms. Celine Bahadur, a person who never talked about the 911 tape or listened to it or heard anything, but had her own sort of interesting take on the evidence presented and her view of it. And then Sergeant Ramondo came in sort of just to bring in just information, no substantive testimony. Similar with Diane Smith, she came in and identified a lot of exhibits, so he was able to sit through that, but there was nothing having to do with voice identification whatsoever. The second day, he heard, I guess, or at least was in the courtroom, from Mr. Dyker's testimony. It was during that break that, and I'll proffer that Mr. West noticed that Mr. Donnelly was in the courtroom and had him leave, but we'll proffer that if necessary. So he was able to hear at least the first half of Mr. Dyker's testimony, during which he didn't say anything about anything. It was the second half. But even if he was here for that, you know her testimony to be that she heard somebody scream. She didn't listen to the 911 call. She didn't opine regarding the 911 call. So he was out of the courtroom at that point. And he's, of course, present and waiting all day to testify to acknowledge this. But just so we're clear as to the violation, we also need to be clear as to what he changed, because I contested the state's suggestion yesterday that he changed his testimony. Because I said, well, he added to it, but the case law that we talk about, and that I'll talk to you about in a moment, really speaks to the infection of that testimony. It really speaks to how a witness has changed their opinion regarding something. What he did was not change his testimony. He added to it by, for whatever reason, waiting until 2 or 3 days before trial or during trial to make the, whatever that emotional decision was he went through to actually listen to something which he listened to. But that was not a change in testimony, though it is added to it. And then the question is, did the violation of the rule that obviously occurred infect that testimony? I'll suggest to you, since what he heard had nothing to do with what he eventually testified to, that it didn't. Did it prompt him to finally come to grips with the fact that he should listen to the tape? Yeah, maybe so. Maybe it did. But to the substance of the effect, we then have to look to some of the cases that I presented to you. Del Monte, which is a 1985 Third DC Act case, which interprets 616.1, sort of gives us some insight, because you need to make a determination whether or not the rule has been violated, and you need to look into the circumstances as to what you should do with it. And Mr. Manti was straightforward when he talked about the sort of seminal case talking about this, which is the Dumas case, a 1977 Florida Supreme Court case. And basically, what that needs, that you need to look into, is to get an identification of whether or not there's been some connivance or collusion between the two, and whether or not we did this in some form or fashion to just, in effect, violate not only the geography of the rule, was he in the room, but the underlying substance of the rule. And I would suggest to you that under the Dumas case, the state has woefully failed to suggest any case law that identifies that a willful violation occurred, nor a substantive violation that may have occurred. The other case law, if I might have just a moment to find it. Sorry, deals again with this court's sort of requirement to make an identification of the violation, the substance of the violation, and whether or not it's appropriate to issue any sanctions. If so, then you have the right, the most significant of which, or the most severe of which, is that you can exclude the witness from testifying. Certainly, there's nothing in the way this matter occurred as to Mr. Donnelly that suggests not only was it not the defense collusion or connivance or even knowledge, but neither Mr. Donnelly's, and you'll hear testimony from him in a moment, but to proffer it, if the court were to allow, when the family, we weren't calling him as a witness. He was on the witness list, but as you know from what we did call him for, specific to the voice, that we were not calling him for any other reason. There was nothing that we were bringing him for substantively until Saturday came and I found out that he had relevant testimony concerning voice, that he was even being called as a witness, just so we're clear about that. But he was definitely on the, I'm not suggesting that that takes him out, but I think that it does affect our presentation and what we were going to do, so that the idea that he may have been around would not have even sort of been effective to us in the way we were handling our witnesses. And I think what happened was, once the state invoked the rule and refused to allow Mr. and Mrs. Zimmerman to be here, and Shelley Zimmerman was here by herself, that she requested Mr. Donnelly to join the seat, I guess the row behind her. And that was just so you understand sort of how this whole thing began, with Mr. Donnelly coming into office support to Ms. Zimmerman. And again, since I had never met him, Mr. West, I think, met him at his deposition, but we had certainly not pre-tried him as a witness, as we've heard some testimony here before, because, just so you're clear, we had no intention of calling him. He just had nothing substantive to offer. So that just sort of comes in mind with this suggestion that we had any knowledge or connivance or collusion with the witness. So if, in fact, there was a technical violation of the rule, then the question is, what is the remedy? Before you consider any remedy, I think that you need to find that, in fact, not only was there a technical violation, but there was some true substantive violation. That, in effect, having violated the rule, he gained some knowledge that was able to sort of mold into his testimony before the court. And there's been no finding of that. There's been no evidence or suggestion of that. And in reality, we know what his testimony was, because it was quite limited. It was limited to testimony that he created, if you will, on Saturday before he testified. And if I'm remembering correctly, and I am, that was after he had removed himself from the courtroom some 5 days before, on that on that Wednesday morning during the morning break. So again, if we sort of look at what happened, he was in the courtroom during a time that he wasn't going to be a witness, but still on the list, left the courtroom when advised to by co-counsel, and stayed away from both the courtroom and the trial testimony until he took on himself to listen to the tape, came to me, talked to me, and I presented him as a witness. So I don't believe that there has been any showing under the cases I presented. Again, Del Monte, Dumas, there are some other cases, but they stand for very similar presentations. Bizard, B-I-Z-Z-A-R-D. Just for the site purposes, that is 674 Southern 2nd, 1382. And Atkinson, federal, I'm sorry. Atkinson versus State, 317 Southern 2nd 807. Wright versus State, a Supreme Court case back in 1985 that does give some good insight into what the court should look at before making a determination to exclude any testimony. And again, the benefit in a case like that goes towards the admission of testimony and certainly towards the defendant's right to present testimony supporting his defense. There are other cases. McKinsey was also cited by the state. I won't recite that now, but only to state that the entirety of the case that I presented, from the cases I've cited to McMahon at 104 Federal Reporter, 3rd, 638, Stiles versus Bergeron, Bargeron, 559 Southern 2nd 365, certainly give the court discretion in making a determination of what sanction to impose, but all stand for the proposition that before any sanction is imposed at all, you need to have a quantum of guilt before you impose a sanction. There has been no guilt shown. There has been a technical violation without substance, and though it is unfortunate that it occurred, it was certainly not, as the state might have suggested, some course of conduct, because I think Mr. Good is now a non-issue as to how that occurred. I think that's not only not a violation, it's wholly appropriate and necessary for an expert to properly present his expert testimony. And Ms. Bertolon.
Your sequence of events here, you had indicated that Ms. Shelley Zimmerman wanted Mr. Donnelly to be in the court with her. However, she was subject to the rule of sequestration also, and that occurred either at or during opening statements. So she wouldn't have been here for the first or third day of trial, actual trial testimony.
No, she wasn't here then, but she had made the
Well,
request.
but you said that he came to support her.
My understanding was that she made the request to come by and support because Mom and Dad were excluded from the courtroom. Then she was excluded as well, but she asked for him to support George, in effect, Mrs. Zimmerman, by sitting in the row, but he couldn't sit in the family row. He sat in the row behind her.
Well, I don't know I'm not clear as to what all the seats were, but my impression is to my left, the very first row is supposed to be a buffer row with law enforcement ability to be on there. The second row is the Martin family row, and they can choose who they want to be on that row, and they have to notify the sheriff's office and Ms. Kennedy regarding who they intend to have on that row. And then the rows behind them, except for the last row, which is media, but the rows in between are lottery. People have to go by and get a lottery to be able to be part of the public. To my right, the very first row is a buffer row, law enforcement and others. The second row is the Zimmerman family row, and they have to go through the same procedure that they have to have authorized who appears or is allowed in the courtroom on those rows. And the rows after that are media rows. Am I wrong in my seating arrangement? So are you saying that Mr. Donnelly was seated in a media row and not the Zimmerman family row?
No, I don't want to offer facts beyond my knowledge. I had not met the man. I've seen pictures, so I know that he was in that side. I think Mr. West, had approached him a moment ago with some better insight on the facts. I don't know. I don't want to have co-counsel argue, but maybe he can clear up those facts. I just know that I saw pictures of him in a courtroom on the right side. My understanding was that he was requested to appear to offer support to George because George's family was excluded. And beyond that, Mr. West may be able to offer some factual insight.
Okay, Mr. West, please.
Well, of course, the issue of whether or not Mr. Donnelly was here, I think, has been addressed, that he was here on Tuesday and then part of Wednesday morning, and which witnesses may have testified during the time he was here, I think is addressed. I had met Mr. Donnelly at the time of his deposition, so I was able to recognize him. And when we took that morning recess on Wednesday morning, As I was exiting the courtroom, Mr. Donnelly was standing there and said good morning, and we shook hands, I believe. That was the first time that I noticed that he was in the courtroom. Certainly Mr. O'Mara didn't, because he wouldn't have known how to recognize him. The clerk would have the time when that morning recess took place, but it was whenever that was, as I recall. I mentioned to Mr. Donnelly when I recognized him that the court had invoked the rule of sequestration and that he would have to leave the courtroom and would not, as a possible witness, would not be able to attend any of the court proceedings. He apologized to me, acknowledged that, of course, he would do that, and didn't express any knowledge specifically about knowing the rule had been invoked previously. To the extent that that was not communicated to him, that's the responsibility of counsel or staff. I don't have any question in my mind that Mr. Donnelly was not specifically informed about that. There's a couple of hundred witnesses on the list. There were efforts made to contact the witnesses that we anticipated would likely be called, and as Mr. O'Mara said, we did not at that time think Mr. Donnelly was on the list. So that's basically it. I didn't tell Mr. Donnelly, nor did anyone with my office tell Mr. Donnelly specifically prior to him appearing in the courtroom that the rule had been invoked and that he could not be here. I don't believe anyone specifically from Mr. O'Mara's office told him. To the extent that didn't happen, it's our responsibility. I have no reason to think Mr. Donnelly flaunted or in any way disobeyed an order that he was aware that the court had put in place through the rule of sequestration. So all of those facts would suggest that the violation was inadvertent on his part, and to any extent that there was some responsibility for it, it lies with myself or with staff.
Okay, thank you.
As to the Shelley Zimmerman issue, I
Or
have
to where
limited...
he was seated?
Pardon me?
Was he
I-
seated in the Zimmerman what's referred to as the Zimmerman family row, which would be the second row to my right?
I can't speak to that because he wasn't seated.
I can't tell by the
He wasn't
pictures.
seated when I saw him. He was standing in the corridor here, exiting a row, but I didn't note specifically which one it was. The information I had was that when the rule was invoked and all of the Zimmerman family that was on either the state's list or ours was excluded from the courtroom, no exceptions, and that because Ms. Shelley Zimmerman, who of course, as the court will note, the state did not call, but was nonetheless excluded from these entire proceedings, asked Mr. Donnelly, could he be here as support for Mr. Zimmerman? So that's my best understanding of the sequence. I was not party to any of those conversations.
I fit up the question. He was in the second row, Your Honor.
Okay, thank you.
2 points based on what I've heard, Your Honor. McKinsey, which is the 845 Southern 2nd 316 case, says as follows. Where the violation was with the knowledge or consent of counsel, the testimony must be excluded. That is under head note 1. What I've just heard is that it was known that the witness had been here. It was known that he was then told he had to leave because of the rule. Later on, he was in fact disclosed his new testimony, changed testimony, or added testimony, however we want to characterize that. And the fact that he had previously been here in violation of the rule was disclosed neither to this court nor the state. Scipio, which is 928 Southern 2nd 1138, says only if the court can determine beyond a reasonable doubt that in this case the defense, but the state, was not procedurally prejudiced by the discovery violation can the error be considered harmless. I would point out that even accepting everything we've just heard is true, it would certainly be within the court's purview to find that that's exactly what has happened here and that his testimony, in fact, under McKinsey, must be excluded, irrespective of the Dumas analysis. As McKinsey makes clear, these are two separate analyses. One is where counsel knew about the violation and it was not disclosed. And the other is, if counsel did not, we then go to all the Dumas factors about whether the testimony was in fact infected. I would point out that Mr. Crump was also forced to be absent from the courtroom and never called. Thank you.
Okay, or counsel, it may then exclude the witness only if it finds that the testimony of the challenged witness was substantially affected by the testimony he heard, to the extent that his testimony differed from what it could have been had he not heard testimony in violation of the rule. And I think that that is very telling to the court. And on one hand, the court is very, very, very concerned. For those who want to know, that was 4 varies. About the rule of sequestration and the witnesses and counsel abiding by that rule. And the question comes whether or not the witness themselves had the knowledge. And based upon what I heard from counsel, I do not believe that Mr. Donnelly had the knowledge because it was relayed to the court that he was not specifically told. In a case like this where there is a couple of hundred people on a witness list, it is a little insurmountable to notify every single person on that list that the rule of sequestration has been invoked, and especially in light of the fact that not even, one half of those witnesses were called during the trial. So I cannot make a finding that he had the knowledge. Now, would his testimony have changed from what he heard? I am not making that finding either. So the motion for sanctions is denied. And if counsel will approach for just one moment. All right, the next order of business is going through the proposed jury instructions and knowing that there may be some suggested changes to some of the substantive ones, the court wanted to go through just the general instructions at this time to see if we can at least have an agreement as to those. First one, although it's not membered, it's just thanking the jury for their attention during the trial and paying attention to the instructions I'm about to give. Is there any objections from the state to this instruction?
No, Your Honor.
From the
No, Your Honor.
defense? Okay. And Mr. Zimmerman, you don't have to stand up. Do you have a copy of these instructions that you can look at them with us?
Yes, Your Honor.
Okay, if you'll please do so, I appreciate it. Yes. Okay. The very first page is just the style of the case. The second page is what I just read.
I'm sorry, were you addressing?
No, you may be seated.
No objection. Is that what you're asking?
Yeah, I wanted to make sure Mr. Zimmerman had a copy in front of him.
He does, and he's reviewing them with us, Your Honor.
All right. Then the second page is the statement of the charge. Any objection from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Neither one of you have to stand while we go through these. Will reserve as to the homicide instruction because it's substantive. And any suggested changes by either side, if you could give them to the other side tonight via email, so we can discuss them tomorrow. The same would be second-degree murder instruction. The next, we'll reserve that until the morning. The next one is possession of a firearm and discharge causing death. Is there any objections to this by the state,
No, Your Honor.
by the defense?
Substantively, no, Your Honor. I believe that it's appropriate based upon the charge. We might readdress that when we go over second degree, but I think it's accurate.
Okay. The next one is when there are lesser included crimes or attempts, and what the state has listed in the proposed instruction is manslaughter and aggravated assault. Is the state requesting these lessers?
Yes, Your Honor.
Any objections from the defense?
We object, Your Honor, and I think that would be something to take up tomorrow.
All right. Manslaughter is a substantive one we'll bring up tomorrow. Aggravated assault is a substantive one. Possession of a firearm and discharge causing death, is that a? Is that the same as the one that,
Because I don't see it in mine the second time, Your Honor. I thought we just addressed that one.
It is, as it relates to the aggravated assault, lesser is where it is.
but it's the same
It is.
instruction, and when the instructions are read, would there be any objection to not reading it a second time? Okay.
I think as long as there's a reference made and we can sort of, if the aggravated assault lesser is given, as long as there's a reference made to the use of a firearm before, because that's the 1020 life enhancement, and there are separate ones for aggravated assault than there are for second-degree murder.
Right. The next instruction is the justifiable use of deadly force, and that's going to be subject to discussion tomorrow. And please, both sides take into consideration the changes that are currently before the Supreme Court on that instruction, so we need to have some agreement as to how that's going to be presented to the jury. Plea of not guilty, reasonable doubt, and burden of proof. Any objection from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Date of crime, any objection from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Venue, any objection from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Weighing the evidence, there's 1 through 5 are always given, and then we have 6 through 10. Is the state requesting any of the 6 through 10?
I believe certainly 8 should apply, and I believe that is the only one the state would be requesting.
Is the defense requesting any others of 6 through 10?
None of those, Your Honor. I'd like to have a presentation by the state on the inconsistent testimony.
Well, both sides have tried to impeach by deposition testimony or other testimony of the certain witnesses, so I do think that that does apply.
Fair enough.
Are there any 6, 7, 9, or 10 neither side is requesting?
No, Your Honor.
Can you please prepare a new instruction that has 1 through 5 and then number 8 as number 6?
Yes, Your Honor.
Thank you. Expert witnesses, any objection from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Defendant testifying will not be given, so defendant not testifying. Any objections from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Defendant's statements, any objection from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Rules for deliberation, any objections from the state?
No, Your Honor.
From the defense?
Other than I don't know what we want to do with possibly 7. I don't think there were any questions written that were not asked by the court. A couple of the jurors asked some oral questions more along the lines of could a witness speak up or that sort of thing. So I don't think 7 needs to be there.
Is there defense agree with that?
We do, Your Honor.
So number 7 will not be given if I can have an instruction that takes out number 7.
Yes, Your Honor.
The next instruction is regarding notes. Any objection from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Cautionary instruction. Any objection from the state?
No, Your Honor.
From the defense?
No, thank you, Your Honor.
Verdict. Any objections from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Submitting case to the jury. Any objections from the state?
No, Your Honor.
From the defense?
No, Your Honor.
And then we have a state's proposed special jury instruction number 1. We'll argue that tomorrow. Are there any other proposed jury instructions that are not covered in this packet from the state?
Not at this time, Your Honor.
From the defense?
I apologize. I was using a copy that I guess I now see it. I didn't have the state's proposed special.
It's the very
It was in
last page.
Last page that they gave me just now. Okay, thank you.
All right. Other than what we've discussed with the substantive ones that may have some changes, are there any other special instructions going to be requested by the defense?
There will be some. Oh, other than the ones we've just discussed?
Right, the
No.
ones that I'm reserving on, changes that may be to that, are there any additional proposed special instructions?
No, Your Honor.
I'm going to need a proposed verdict form,
Yes, Your Honor.
and if you can give a couple of scenarios, one that includes both lesser included offenses, one that includes one and then the other lesser included, and then they have to include the firearm.
Certainly.
Are there any other matters that we need to take up this time regarding the instructions?
No, Your Honor. Thank you.
Just so I'm clear, the defense will be requesting some proposed special instructions, but we're going to get
Just
those later?
changes to the instructions on the substantive charges. Is that correct?
That's correct.
And those will be exchanged tonight via email. Well, you could talk after court about that, and otherwise they will email it to the state overnight so we could be prepared to talk about it in the morning. Do you think it's going to take more than an hour tomorrow to go over these jury instructions?
Hour or so.
So then
according
we'll
to
be
the
back in
argument.
recess at 8:30 because I have the jury coming in 10 for closing arguments.
I'm going to ask that we delay closing arguments for enough time to give both the state and the defense time to prepare for what we have to do tonight, for tomorrow morning, and then for closings. There's a lot of testimony, a lot of evidence, and
All
it
right.
just
We'll
needs to be
begin
organized.
closings at 1. And we'll let the state go through their closings. The defense can do their closing on, tomorrow is what, Thursday, Friday morning. The state could do the rebuttal Friday morning. I could charge the jury, and they will go out to deliberate Friday afternoon. Does that give you enough time?
It does.
Then I need to let the sheriff know that we don't need the jury until 1 tomorrow afternoon. And counsel, what time do you want to come in and go over the jury instructions?
I thought you said
9?
8:30, but
8:30 is fine.
I just didn't know if are you asking to change that?
Well, we just talked about it, and you
Oh,
said you
sorry.
wanted time for your closing. I don't know how much time the state's going to need. Do you want to start at 10 o'clock on the instructions? Do you want to start at 10:30 on the instructions? Or do you rather do it in the morning? Because you're not going to start your closing till 1 in the afternoon.
Early in the morning would be better, and Mr. Manti will be representing us. I just need to update my
So what are you
closing
saying, you get
argument.
to sleep later than Mr.
No, I'll be
Manti?
here, at 7 or earlier, probably 6:45. But I'm just saying, I would like to have more time to be able to input whatever changes are made into my closing argument presentation. So I would prefer at 8:30 or 9 o'clock if we could.
9 o'clock it is. Court will be in recess till 9 o'clock. We'll have the jury in at 1. Is there anything else that we needed to take up tonight?
Now that we've moved to Friday, does it not make sense to just start closings Friday morning? And then this way we get all the closings in one day and the jury gets charged?
The reason I
in one
told
day?
you what schedule I wanted is because it makes sense to me. Okay? And it gives you the time, it gives you plenty of time to prepare for your closing. And the state has indicated they don't need any more time, so we'll be in recess till 9 a.m.